Welcome to Rochester Law Center, and thank you for being with us. Today, we're going to be talking about the differences between a trustee and an executor. If you're confused about the differences between a trustee versus an executor, you're not alone. We often get asked about this topic at Rochester Law Center. If you're researching this topic, you're probably in the process of determining which estate planning tool is best for you to pass your money and property to your family and loved ones after you pass away. Or you may be an individual who's just found out that they were named the trustee or executor of an estate, and you're trying to find out what this all means and what you're supposed to do next. If you find yourself in either situation, the information we'll discuss today will help answer the following. What is the role of a trustee versus executor? What's the difference between executors and trustees? What are the responsibilities of an executor? What are the responsibilities of a trustee? And who should be a trustee or executor? Executors and trustees are very similar. In many states, like Michigan for example, executors are called personal representatives. If we use these terms interchangeably, don't be confused. We're referring to the same role. Both trustees and personal representatives are individuals who are selected by another person to be in charge of managing that person's estate after they've passed away. This includes things like settling any outstanding debts and distributing the remaining assets to the heirs of the deceased. This is known as settling an estate. So what's an estate? An estate refers to all of the money, property, and assets that the individual who passed away owned at the time of their death. So what are the differences between a trustee and an executor? One of the major differences between the two is how they're appointed. A trustee is appointed in a trust document, such as a living trust, to manage the estate of the person who passed away. A personal representative, on the other hand, is named in a last will and testament, oftentimes referred to as a will. The second major difference between a personal representative and trustee is the process they have to go through to settle an estate. Wills and trusts act differently. As a result, the process a personal representative and a trustee has to go through to settle an estate is slightly different. To get a better understanding of the differences, let's take a deeper look at how a last will and testament works and the role of a personal representative. A last will and testament is a legal document that gives instructions to the court on how your assets should be distributed when you pass away. In your last will and testament, you name a personal representative. This is the person you want to settle your estate and make sure that your wishes are executed appropriately. Their responsibilities include handling problems with creditors, fighting objections from omitted heirs, managing the transfer of your property, and making sure that each of your devisees or beneficiaries receive their inheritance. The major drawback of a last will and testament is that your estate must go through probate, a process that in some cases can take months or years before your assets are distributed to your heirs and your estate is settled. This means that the person you want to be your personal representative will be responsible for obtaining letters of authority from the probate court and guiding the estate through the complicated probate process. Getting letters of authority and navigating the probate process can be complex. In some cases, probate can take years, especially if the will gets challenged. If you find yourself in the role of personal representative and you need help navigating probate, it's usually best to consult with an experienced probate lawyer. If one of your goals is to avoid putting your family through the difficulties of probate court, you should consider a living trust instead of a will. If you do choose a living trust, you'll need to appoint a trustee to manage and settle your estate when you die. To understand the responsibilities of a trustee, let's briefly explain how a living trust works. When you set up a living trust, you legally transfer your property into the trust and manage it yourself while you're alive, just like you do now. This means that while you're alive, you're both the grantor and the trustee. But someone needs to manage the trust after you die so that your assets in the trust can be distributed to your heirs according to your wishes. The person you appoint to take over the role of trustee after you die is known as your successor trustee. When you pass away, your successor trustee takes over as trustee and manages and distributes your assets according to the strict directions you've outlined in the trust document. Overall, responsibilities of a trustee are very similar to those of a personal representative. But there's one big difference. Trustees do not need to go through probate in order to settle the estate because living trusts avoid probate court. This is one of the major advantages of a living trust. If you've recently been appointed trustee and need help with the trust administration to properly settle an estate, you can always reach out to an experienced trust lawyer to help. So who should be a trustee or executor? Being a trustee or executor is a big responsibility. As a result, you should choose someone that you believe has the ability to manage and settle your estate according to your wishes. Many people choose a close relative or friend. It's a good idea to choose someone who's capable enough to handle the responsibility, and ideally, someone who is good at handling money and financial transactions. Most of all, you want to choose someone who is honest and trustworthy. A trustee and personal representative have similar roles and responsibilities when it comes to settling an estate, but they also have some key differences. One key difference is that the trustee is appointed in a living trust and a personal representative is named in a last will and testament. The second major difference is that a trustee does not need to go through probate to settle an estate because living trusts avoid probate court. If you're trying to determine if a will or a living trust is the best estate planning tool for your situation, or if you've recently found out that you've been named trustee or personal representative and you're looking for the services of an attorney to assist you, we can help. Over the past decade, we've helped thousands of clients with all matters of wills, living trusts, probate, and the settlement of estates. To set up a free initial consultation, just give us a call at 248-613-0007 today. We offer phone and web consultations in addition to traditional in-office meetings. Let our staff know that you prefer to meet with one of our attorneys in the comfort of your own home via phone or web conference, and we'll get you scheduled based on your preference. Call us today at 248-613-0007. Again, that number is 248-613-0007. Thanks for joining us today, and we hope to hear from you soon.